Hi, I'm Kleinheisterkamp, and welcome to the second presentation of the series New Thinking on Investment Treaties. I'm going to be talking today about the topic of no greater rights. How can we have no greater rights for investors and still have meaningful investor protection? I'm going to be arguing that we need more coherence between the national and international level of protecting rights of individuals, of companies, against government interference. And let me show you this letter. This is in 2013, a letter by the US Trade Representative Morantis at the time to the House of Representatives in the US, where he explained the government's policies and objectives for the negotiation of TTIP. And in the very first line, he said regarding investments, that the objective was to seek to secure for US investors in the EU important rights comparable to those that would be available under US legal principles and practice, while ensuring that EU investors in the United States are not accorded greater substantive rights with respect to investment protection than US investors in the United States. That's interesting. Comes back from the 2002 Trade Act, influenced by litigation in the Methanex case, where a political decision was made that foreign investors should not be granted greater rights when they come to the United States. Interestingly, a few weeks later, 2013, the EU Intercommittee on International Trade voted for an amendment of what is now the regulation on managing financial responsibility of the EU linked to investment arbitration, and included a recital which reads as follows: Union agreements should afford foreign investors the same high level of protection as EU law, and the general principles common to the laws of the member states grants to investors from within the Union, but no greater level of protection. So an echo on the other side of the Atlantic that again, US investors should not get greater rights than EU investors have on the internal market of the EU. Is that important? Clearly yes. It sounds like an old voice. Some people will say that is just the old Calvert doctrine, but it is the most pressing political issue that we have now in the negotiations of TTIP. So, what is actually the problem? It's the little differences. Example. Let me give you the example of the divorce of secondary from primary remedies, and I hope to illustrate what this means. If there is a breach of an individual right in a domestic sphere by a public measure, then that individual, that company, that investor has two choices. There are the primary remedies, which is the judicial challenge and the attempt to try to get setting aside of the public measure to remove the obstacle to be able to continue to do the economic activity, and the secondary remedies are to claim for damages for the resulting losses, the losses resulting from that interference with the private rights. Now, it is not really a choice under domestic laws, at least not in most countries. You first have to challenge the measure that you are affected by and try to obtain it setting aside. You cannot simply go right to the damages. If the measure is illegal, it will be set aside, and then you may be entitled to damages, but only for those arising between the period of the breach until the moment of the judicial remedy setting aside. After that, the economic actor has to continue its economic activity and actually bear the commercial risk of making that money which was expected. You cannot simply endure the measure and cash in, which is an expression that comes from German administrative law. Now, this principle is not just German, even though I do recommend reading the two decisions of the German Constitutional Court in this respect, which are very good, but it has been also recognized at the EU level by the European Court of Justice that this principle of first having to attack and challenge the measure and only then being able to ask for very limited damages, that is a general principle common to the laws of the member states and therefore also EU law. And I will come back to that later. So, but what happens if the measure is legal? In principle, the answer is simple. You cannot get damages because there is no breach. Can you get other type of compensation? Well, you can get compensation if there is expropriation, if property rights are taken away. However, at least in Europe, in most countries, we have a rather formal understanding of expropriation. What some investment tribunals have qualified as indirect expropriation is, for example, under German constitutional law, the definition and the limitation of a property right, which is, however, exclusively reserved to the legislature. And the legislature has to define what kind of compensation has to be granted. It is not the courts which can review this. The only review allowed is if the legislature acts disproportionately, excessively, by, for example, not giving any compensation whatsoever. And even then, that doesn't mean you can claim for that compensation in court. It just means that you can then attack the law, the act, and it will be set aside, and a new law has to be made. Then with an adequate compensation, but which is defined by the Parliament, not by the courts. Now, in the sphere of the European Court in the European Court of Justice, we have had cases like that, and the European Court of Justice has been very clear on this. It has said that the exercise of the legislative function must not be hindered by the prospect of actions for damages whenever the general interest requires legislative measures to be adopted and which may adversely affect individual interests. This is a very clear expression of needing a safeguard against regulatory chill. The legislature, but also the government, must be able to act in the public good without fearing to have to pay compensation. In the same decision, the European Court of Justice said, in a legislative context, the community cannot incur liability unless the institution concerned has manifestly and gravely disregarded the limits of the exercise of its powers. It is only in this very narrow situation, very exceptional situation, in this situation of disproportionality, where any kind of compensation can be due. This has also been again recognized by the European Court of Justice to be a general principle common to the laws of the member state, and that in its Grand Chamber, against the Tribunal of First Instance and against the opinion of the Advocate General, who had pleaded for a more generous approach. But it is the balancing of the private against the public interest which led the European Court of Justice to establish this principle that there is no compensation for special burdens on individuals resulting from economic policy choices where these are legal. This was established or reaffirmed recently in the FIAM decision, and in this FIAM decision we talk about a situation in which European investors had been affected by sanctions imposed against the European Union after the European Union had failed and refused to comply with the ruling of the WTO panel relating to the bananas dispute. And then these European companies, which suffered a loss from the sanctions imposed by other countries, claimed that money as a kind of special damage that they had to suffer because the EU did not comply with international law. This was, again, very clearly rejected by the European Court of Justice, which stated that there is no liability regime under which the community can incur liability for conduct falling within the sphere of its legislative competence in a situation where any failure of such conduct to comply with international agreements cannot be relied upon before the community courts. What this means, briefly, is that because WTO law provides for remedies for its breach, but does not confer any special individual rights, but only obliges the states to find a solution, the individuals cannot then claim for compensation under their domestic regime. Put it differently, the measures taken by the EU, even though contrary to WTO law, leading to the sanctions, were legal from an internal perspective. And arguably, even under WTO law, the EU was entitled not to comply with the ruling and just to endure the sanctions. Because the individuals affected by that do not have a right to invoke WTO law, they are also not entitled to get compensation. Sounds hard, but it preserves the policy space, which is inherent to EU law, but also to WTO law. Now, what about TTIP? Would that change? And I leave the same phrase up there with a slight modification, because the investment chapters in TTIP and CETA are actually establishing a liability regime under which the community can incur liability for conduct falling within the sphere of its legislative competence in a situation where any failure of such conduct to comply with the international agreement can be relied upon before, not the European Court of Justice, but before investment tribunals. That means we create a new type of liability, which then actually gives the foreign investor a different standing and a different right than the EU investor in the internal market. So, is there a greater right? Probably yes. And to continue, again, the European investor is stuck by the logic of our administrative and constitutional laws, which have a good reason to be that way, which is you first have to challenge the measure, and only then, if successful, you can get damages for the resulting losses. Which means you first have to go to court, in your domestic system, you may then go up to the European Court of Justice, maybe through the preliminary ruling mechanism, and you will get your rights and a decision on the legality or illegality of the measure that affected you, but you cannot right away go and claim damages. The European investor is therefore differently treated than the foreign investor. The foreign investor can opt between going under domestic law to local courts, challenge the measure judicially and setting aside, and maybe claim damages for the losses suffered in between, or, and this is the difference, the foreign investor can invoke international law. The foreign investor can invoke a bilateral investment treaty, he can invoke investment chapter of TTIP one day, maybe, and that is then before international tribunals, which means there is a difference, which becomes even more obvious when we think about the provision in many of those treaties, which is the fork in the road provision, which is also suggested for both CETA and TTIP at the moment. This is a serious problem, because this means that if the investor takes one avenue or the other, he's barred from taking the other, which means if he chooses under international or under the investment treaty to claim for damages, the investor cannot any longer challenge the measure before the domestic courts. But that means that the damages are also significantly different. Whilst when you go to domestic courts and remove the obstacle that has caused you a problem, your damages are actually limited and you continue your activity. If you cannot go that way because you are going under the international regime for damages, those damages are then entirely different. Think of a project over 20 years, which runs into a serious problem after 5 years. In that situation, we will calculate the damages for the remaining 15 years, which is of course an entirely different measure than under domestic law. And that type of reasoning, that type of privileging the foreign investor makes sense, or made sense, in a time where we perceived many countries in the world to have very deficient rule of law systems, that they did not provide the sufficient rule of law. And here you see a map of those countries which have a bilateral investment treaty with Germany. And you will see, with the rare exception of Spain, that all of these countries are what we would call either second or third world countries, which were at the time when the BITs were concluded, countries which received German capital, but which certainly did not bring capital into Germany, which means those provisions were designed to protect German interests abroad, not foreign interests in Germany. That is at the core of the current debate. There's a realization those treaties were not made for us. And if TTIP or CETA were to be based on those models, we would be imposing ourselves a regime which was designed for countries which have deficient administration, which do not respect rule of law sufficiently. So we have to think about how to redesign these new regimes of liability. So how can this problem be solved? A quick proposition. First of all, we have to think about the substantive law provisions. Part of the problem is that domestic law rights and rights of an investor under international law may be substantially different. We just have to think about the difference between expropriation, indirect expropriation, definition and limitation of property rights, which I already mentioned. But how can we bring these two bodies of law into coherence? How can we make international law be in phase with our domestic laws, which are rather developed? That is something which also the European Union had to face very early on, when it had to define its own liability, its extra-contractual liability, its state liability. The European member states did not do that by a specific provision, but merely referred in Article 340, paragraph 2, to the general principles common to the laws of the member states, which meant that you have to engage, and means that what the European Court of Justice has actually done, for example, especially in the FIAM decision, is to go through the different laws of the member states and try to distill out of that the rules which then are common to the tradition of the member states and therefore also binding on the European Union. And of course that echoes Article 38(1)(c) of the ICJ statute, which also provides that if there are no treaties, if there is no customary law, then international law has to draw from this common tradition of the states so as not to be out of line with the policy choices made. Which means also that if we want coherence between domestic and international law, for example, in TTIP, we will have to go into comparative law studies of the administrative and constitutional laws and the law of state liability of the member states of the Union on one hand, and of the US on the other hand. People have to sit together, the negotiators have to know what under their domestic legal systems the protection actually is, and then through comparison start drafting new provisions which are actually in line with that, and so as to make sure that foreign investors are not granted greater rights. So what we have to do is we have to build a substantive treaty law of state liability, not top-down from those old models, those old BITs, which were not designed for countries with both functioning judicial systems and administrative systems. But we have to actually try to build that system bottom-up, and that on the basis of the experience that we have, that courts have developed, and what the legislatures have developed in their policy choices of balancing private and public interests. Legal certainty and policy space are brought together on a daily basis in our national courts and in our administrative procedures. The rule of law is one value, democracy is another value. They go together, they're complementary, not exclusive. Furthermore, we need to reconnect primary and secondary remedies. To go back to my diagram, we have to get rid of the fork of the road logic. On the contrary, foreign investors should go through the same procedures as domestic investors. They should first try to allow the courts to remedy the problems, the wrongs created by public administration or even by the lawmakers. You have to challenge the measure, you have to obtain setting aside if it is illegal, and then you can get compensation even in local courts. Now, not always do the court systems work perfectly well, not always can we exclude discrimination, which means if we then want to have a parallel system of international law, it should be available, but it should be available only after having tried at the local level to actually get rid of the problem. So a local litigation requirement seems to me quite essential to provide for this coherence between the domestic and international level, because it means that first you have not to exhaust local remedies, but you have to litigate in local courts for a reasonable time, which could be expected in complex matters, which investment matters usually are, in local courts. Let's say 5 years. It sounds long, but at the same time, everyone who has experience, even in Germany, with different instances in administrative law knows that that is a reasonable time. The European Convention of Human Rights sets maximum durations for litigation which have to be accepted, but the European Convention of Human Rights itself can only be invoked, or actually the European Court of Human Rights can only be approached once there is exhaustion of local remedies. That is the principle we have established for ourselves in the Union or in Europe, that the international jurisdiction only comes in as an help when you have exhausted local remedies. I'm not pleading for exhaustion of local remedies, but for a local litigation requirement of a substantial period of time, because that will allow local courts to actually remedy the wrongs committed by the administration, if there are any, or the lawmakers. And it would actually allow for that very important dialogue between the judiciary on the one hand and the regulators on the other side, which leads to the development of a true administrative law, to the true balancing of private and public interests. That is what I have to suggest. I hope you found this interesting. If you care for further reading, here are some suggestions which you will also find below this video. One of them forthcoming, the other from 2014. I hope you found this interesting, and all the best. Thank you.